Article 6. Joinder of claims. A. The plaintiff in a complaint or the defendant in an answer setting forth a counterclaim or cross-claim may join as many claims as he may have against an adverse party. There may be like joinder of claims when there are multiple parties. B. Two or more plaintiffs. So key words there are two or more plaintiffs may join no more than 5 claims in any one action or proceeding against the same defendant arising out of separate consumer credit transactions, provided that those plaintiffs are represented by the same attorney. I think I know what that means, so I'm not going to go too deep into it. 602, consolidation. Generally. This is A. When actions involving a common question of law or fact are pending before a court, the court, upon motion, may order a joint trial of any or all matters in issue, may order the actions consolidated, and may make such orders concerning proceedings therein as may tend to avoid unnecessary cost or delay. B. Cases pending in different courts. Where an action is pending in the Supreme Court, it may, upon motion, remove to itself an action pending in another court and consolidate it or have it tried together with that in the Supreme Court. Where an action is pending in the county court, it may, upon a motion, remove to itself an action pending in a city, municipal district, or justice court in that county and consolidate it or have it tried together with that in the county court. So Supreme Court, if it's got an action pending, can remove to itself an action in any other court and consolidate it or have it tried together with that. If it's in the county court, it has to be an action in its county, pending in a city, municipal district, or justice court. 603, severance and separate trials. In furtherance of convenience or to avoid prejudice, court may order a severance of claims or may order a separate trial of any claim or any issue. The court may order the trial of any claim or issue prior to trial of the others. 604. Change by Supreme Court of place of trial of action pending in another court. Change by Supreme Court of place of trial. Upon motion of any party, the Supreme Court may order that an issue of fact in an action pending in another court, except an action relating to real property pending in a county court, be tried in the Supreme Court in another county upon terms that may be just. After the trial, the clerk of the county in which the trial took place shall certify the minutes, which shall be filed with the clerk of the other court where the action is pending. Subsequent proceedings shall be the same as if the issue had been tried in the court where the action is pending. CPLR Article 11, Poor Persons. When someone files a motion to proceed as a poor person, there is no specific income requirement. In general, if a court determines that an inmate has insufficient means to pay the full filing fee, after the inmate files the poor person affidavit, the court may permit the inmate to pay a reduced filing fee, and the minimum shall not be less than $15 and the maximum shall not be more than $50. The court may allow the inmate to begin his action before the initial filing fee is paid. However, note that this subdivision does not apply to an Article 78 proceeding which alleges a failure to correctly award or certify jail time credit due an inmate in violation of the correction law and 7030 penal law. Stuck with deciding what's appropriate to allow them to proceed as a poor person. Upon being notified that a party has been granted leave to appeal as a poor person, the court clerk must within 2 days notify the reporter, and that reporter must make 2 certified copies of the transcript and deliver it to the poor person within 20 days of the notification. Any recovery of a poor person shall be paid to the clerk of the court to await distribution pursuant to court order. Where a motion for leave to appeal as a poor person is brought to the court in which an appeal has been or will be taken, such court shall not remand the motion to the trial court for an initial determination. They have to hear it on the merits there. 1102. The court, in its order permitting a poor person to proceed, may assign an attorney. Okay, so I know this. It's a legal aid society. The attorney just has to file a certification saying the person is indigent, and you don't need the form affidavit or a separate motion. So with the legal aid society thing, they just file a certificate, and it could be either private counsel working on behalf of a nonprofit agency, the nonprofit agency for auspicious of legal services or whatever, they could do it, or it could just be a legal aid society. This form affidavit has to be available in the clerk's office. If the court denies the application, the plaintiff will, by written order, be given notice that the case is going to be dismissed if he doesn't pay the fee within 120 days from the date of the order. So an inmate under sentence for a conviction, whether it's a federal, state, or a local inmate, for a conviction of a crime, may seek to commence his action by paying the reduced filing fee. Upon receipt of the application, the court shall obtain from the official of the correctional facility a certified copy of the inmate's trust fund account statement for the 6-month period preceding the application. The correctional facility should not refuse to give the inmate this paper, but then it also says the court's supposed to obtain it. So the court may require a moving party for poor person's relief to file a certificate of an attorney stating the attorney has examined the action and believes there's merit to the moving party's contention. Article 12, infants, incompetents, and conservatees. Who may move for the appointment of a guardian ad litem for an infant? And it's the infant himself if he's 14 or more, a relative of the infant, a guardian of the infant, a friend of the infant, an adverse party, or the court himself. And I believe that that's all of them. All those people can move for an appointment. Friend of the infant, relative of the infant, pretty much anybody. No judgment may be entered against an infant or an incompetent unless 20 days have expired. 20 days have elapsed since a guardian ad litem was appointed for him. Unless the court appoints a guardian ad litem, an infant shall appear by, 1, is the guardian of his property. There's no such guardian, a parent having legal custody. 3, neither of those exist, then it's another person or agency having legal custody. Or if the infant is married by an adult spouse residing with the infant. The following people that can get a petition for a guardian of the infant is all the same except the guardian himself. It's a parent of the infant, friend of the infant, cousin of the infant himself if he's 14. 1210 sub E, upon the appointment of the guardian of the person or property or both of an infant, the guardian who is appointed shall file a certified copy of the order of his appointment with the clerk of the surrogate's court in the county of his appointment. Also in 1201, a person shall appear by his guardian ad litem if he is an infant and has no guardian of his property, parent, person or agency having legal custody, or adult spouse, or if he is an infant, incompetent, or conservatee, and the court so directs because of a conflict of interest or for other cause, or if he is adult, incapable, adequately prosecuting or defending his rights. Settlement of an action. That if there's no action commenced, a special proceeding may be commenced upon petition of such a representative for settlement of any claim by the infant, and I believe that it has to be approved by the court. And if there's no motion term being held and no justice of the Supreme Court available, they can commence it in a county court, and the county judge can, with the same power as a justice of the Supreme Court, to settle this petition. Okay, so then there's a settlement procedure that they talk about. Then 1209, arbitration of controversy involving infant, incompetent, or conservatee. Controversy involving an infant, incompetent, or conservatee shall not be submitted to arbitration except pursuant to court order made on application of their representative, provided that a claim brought pursuant to the insurance law on behalf of an infant may be submitted without a court order. So that's the one exception, and it only says for an infant, a claim brought on behalf of an infant, 420 of insurance. All right, so this is 1210, petition for appointment, contents. It shall state the age and residence of the infant, the name and residence of any living parent and person proposed as guardian, the relationship he bears to the infant, the nature, status, and value of the infant's estate. Hearing. Court shall ascertain age of the infant, amount of his personal property, gross amount and value of rents and profits during his minority, and the sufficiency of the security offered by the proposed guardian. If he's under 14, the court shall just select somebody. If he's over 14, the court shall examine him as to his preference. Undertaking. The court shall make an order requiring or dispensing wholly or partly with an undertaking in an amount according to and conditions set forth in Section 1708 of the Surrogates Procedure Act. The court may, in its discretion, invest bonds, yada yada. To when they're talking about a settlement procedure for an infant or incompetent, and they need a medical or hospital report, and the claim is for personal injury, the hospital report or medical report does not have to be verified, and it shall be included in the supporting papers. So the reason that this is important is because if you're, they're trying to protect infants and incompetents from settling cases that really are insufficient settlements, or that they're not a settlement in the person's best interest, but the lawyer's making his cut, and maybe the parent thinks that they're going to be able to keep some of this cash, so maybe it's not in the best interest, and that's why it's important for a judge to make sure. All right, so 1211, allowance for infant support. Number one, where can you make a petition? You can make it in Supreme Court, County Court, or Surrogates Court. So 3 places. And it has to be infant support, maintenance, or education, and set forth in detail where the property, whether the parents are living, their relatives, and who's supposed to be supporting this kid. Any application that, if you already made an application, you have to say what happened to it. Notice. Such notice as the court shall direct shall be given to what? Guardian of the property, to infant's father if living, or if not, to infant's mother, or if both parents are dead, to the person infant resides with, and the infant himself is if he's 14 or more. So, if it's like, okay, the infant is we want some money from the infant's estate, but it's actually not for him, no good. And the way the notice is given, it's in a manner the court shall direct. So the court will direct who's ever the guardian or whoever's presenting this petition, the court will direct how the notice will be given, but it has to be given to those people that I just talked about. And I think that's kind of like, unless you're going to sit there and memorize the contents of the petition, the settlement procedure, there's a huge list there. It looks like this. It's kind of like massive. It might be on the test, but just kind of hopefully I'll read it, and I'm not going to say it on the video. It's just too long. And another thing to note, so the adverse party, if there's no attorney for the infant, then the attorney for the adverse party or person can prepare the papers and state that fact. Certified copy of order appointment, only 1 copy. And the fucking chief administrator has to, unless otherwise provided by rules. So the fucking chief administrator could say that thing about the county court if no terms in session, that's not good, I guess. Liability of costs of infant incompetent shall not be liable for costs when they're represented by a guardian ad litem or a representative of such person shall not be liable unless court orders otherwise. This is more from 1202. It says consent. No order appointing a GAL shall be effective until a written consent of the proposed guardian has been submitted to the court together with an affidavit stating facts showing his ability to answer for any damage sustained by his negligence or misconduct.